Yes, Mr. Hedgeman.
My lord, my lady, I was going to move on to deal with the last substantial aspect of the ground one of the grounds of appeal, which is the discrete basis of liability in public nuisance, and particularly the question about whether the defendant was in law able to continue or adopt the nuisance
Yes.
that these poles presented on the highway. I will just return, if I may, to the judgment at tab 6 of the core bundle index, just to highlight to the court where the judge below dealt with the discrete claimant nuisance. At page 93 of the bundle, I can take paragraphs 120 and 121, which are the submissions of the claimant in respect of adopting a nuisance.
Yes.
Those are the submissions that are accepted by the judge below. The claimant's case being, and I appreciate paragraph 120 is quite difficult to follow, but the claimant's case being that the defendant had control so as to enable it to abate a nuisance, then the defendant was liable. So essentially it was being submitted that the defendant had a power to abate the nuisance, and therefore the defendant will be liable. And then paragraph 121, the judge would have submitted to the judge that essentially amounted to adopting a nuisance. The judge accepted those submissions essentially at page 115, paragraph 189 and 190.
Yes.
The judge essentially found that the defendant had adopted this nuisance. The components of that holding being that it had failed to abate it in circumstances where the defendant had control and of which the defendant was aware, so control of it and awareness of it, and had the power to abate. So it seems to be those ingredients, a power to abate coupled with awareness of the nuisance and control over it, which I suspect control really goes hand in hand with the power to abate. That it seems to me, is the basis upon which the defendant was held by the judge to have adopted the nuisance. As I mentioned at the beginning of my submissions, it's necessary to go back to the leading authority on control and adoption of the nuisance, which is Sedley Denfield, as I will in a moment. The court will find Sedley Denfield and O'Callaghan 1940 appeal cases 880 at tab 2 of the authorities bundle. This authority will help us with what adopting or continuing a nuisance is, and they are distinct concepts. I have to say, I read between the lines almost that when the judge found that the defendant had adopted this nuisance, he must have meant continuing it, because on no basis can there be an adoption of a nuisance if the defendant's not making use of the nuisance. As I understand the definitions of those terms to be.
This is an area where the authorities are riddled with inconsistent use of language,
Yes, absolutely.
which doesn't help.
They're used distinctly, they're used to refer to the same thing, to different things. It's I entirely accept my lord's point. It is confusing. But if we go back to Sedley Denfield and at least see what the definitions mean, as clearly distilled in that authority, and that should, I hope, make the point that at most, and I'll come on to my submissions as to why I say the defendant was not capable of even continuing a nuisance, but at most, in theory, it could have been responsible for continuing rather than adopting a nuisance. I'll mention the facts of Sedley Denfield and O'Callaghan briefly.
Forgive me, I don't know if you've looked. You probably know better than I do. I did a judgment in a case called Jalla, which, as a first instance, which was all about continuing and adopting nuisance after an oil spill, and the only reason I can remember it was I was upheld. But you haven't come across that, have you?
I haven't, my lord. No.
Okay. Well, I'll have a look at it overnight because I think it's 95% likely to be irrelevant. So I don't want to trouble you with it. But if I think it's relevant, I'll let you know.
I'm grateful. The facts of Sedley Denfield are probably worth brief mention. A private nuisance claim between two landowners. The defendant owned a field, which there was a drainage ditch, and at some point in time, a trespasser, which was the local authority, came onto the defendant's land, and in that ditch built a culvert, which was narrower than the ditch. Rather ineffectually, when building that culvert, they installed a grate designed to trap leaves, debris, and so on that would cause the culvert to become choked. They decided to install that on the top of the culvert rather than in front of it, or some distance in front of its opening, where it would actually serve its purpose of trapping things and not choking the culvert. 3 years after that work had taken place by the local authority on the defendant's land, there was a rainstorm. The culvert choked, the water overflowed the ditch and onto the claimant's land, and lo and behold, we have a classic private nuisance situation. The important point was that the defendant in that case essentially said, well, I have a complete defence here, this culvert was installed by a trespasser, and there we are, I wash my hands of it, it's not me. Not something I'm responsible for. In principle, it was accepted that that could be a defence, but not, and this is the important point, not in circumstances where the occupier had adopted or continued the nuisance installed by a trespasser. To deal with the question first about what those terms mean, I will turn to page 50 of the authorities bundle.
50.
Yes. This is the opinion of Lord Wright. I flag here, before I get into the meat of it, if I can put it like that, I flag here 8 lines down from the top of the page, Lord Wright's reference to occupiers. To make the point that the ground of responsibility, the basis upon which an occupier can be responsible for a nuisance, or cause of a nuisance that's installed by a trespasser, is because the occupier is in possession and control of the land from which the nuisance proceeds. Very straightforward point. And it follows, of course, that the occupier is the person equipped to abate the nuisance, to deal with it, has a free and unfettered right to sort it out. So that's why, in principle, an occupier of land can be found liable for continuing or adopting the nuisance. Turning to page 51, there is, towards the bottom of the page, the midpoint of the page, a paragraph that begins, though the rule has not been laid down by this House.
Where are you?
Page 51, my lord, about 2/3 of the way down, a paragraph that begins, though the rule has not been laid down. I would just invite the court to consider that paragraph.
Well, isn't it characteristically pithily put by Lord Atkin on page 46 of the bundle, 899, I think. Lord, 6 lines down. In my opinion, the defendants clearly continued the nuisance, for they come clearly within the terms I mentioned above. They knew the danger, they were able to prevent it, they omitted to prevent it.
Yes.
But it was a danger coming from their land.
Yes.
Yes.
No, I wasn't. I'm in a state of confusion here. How does this all relate to a nuisance on the highway,
Because
where your clients are not occupiers of any part of it?
Because it is said that the defendant was capable in law of continuing the nuisance left by the market trader who deposited the property.
They came upon it on the highway and then continued it. Is that the way the case is put? I'm sorry. I probably shouldn't be, but I'm confused about how Sedley Denfield translates to a case where what we're talking about is an obstruction on the highway.
Yes. Well, where I'm going to go, my lord, is Sedley Denfield tells us what continuing or adopting a nuisance means. Makes very clear that it's part of reciprocal duties between landowners. And it stems from the fact that occupiers have the power to abate the nuisance, and so that power means that they can continue it. My submission is ultimately going to be that that is where this line of authority is confined. But the claimant in this case says, and the judge in fairness found, that the defendant local authority adopted, or perhaps more realistically, continued the nuisance. Now, there are some passages from the speech from Lord Scott in Gorringe, obiter passages, where there was a suggestion that a highway authority may be liable for a public nuisance created on the highway. But then the decision of this court by Lord Justice Dawson, as he then was, in a case that I'll take the court to called Alley in Bradford, made very clear that Sedley Denfield should be confined to exactly this situation that my lord has identified, and couldn't be transposed onto a public nuisance on the highway.
Thank you.
So
that's where you're going.
That's where I'm going, my lord. But
Yeah,
I
I'm
thought
sorry
before
to
I
be
get
confused.
there, I should define and what these terms continuing or adopting mean. But as my Lord Justice Bean has said, at page 46 we get Lord Atkin's definition of what continuing a nuisance is. Lord Wright at page 51 says essentially the same thing. But I just go to Lord Wright in addition at the top of page 52, because Lord Wright goes, if you like, a little further and describes the rationale for the rule. At the top of page 52, his lordship says, the responsibility which attaches to the occupier because he has possession and control of the property cannot logically be limited to the mere creation of the nuisance. It should extend to his conduct if, with knowledge, he leaves the nuisance on his land.
forgive me for asking again, but in your submission, are you saying that this doctrine is only applicable to occupiers?
Yes, although a slight gloss on that in light of the decision my learned friend relies on. It can be a non-occupier that is nonetheless in significant control.
That's the trees
Of
case.
the trees case, yes.
Yep. Or Justice Dyson.
The point being there that although they're not an occupier, they essentially have occupational control. And I should say, of course, that it is possible for someone to, on their own private land or land that they're in control of, to cause a public nuisance or continue a public nuisance, where the nuisance on private land encroaches onto the public highway, then that, in theory, the occupier of the land or the person in control of the land could continue the nuisance that's caused onto the adjacent highway. And there are cases referred to in certainly Denfield with exactly that. There's a case, for example, where the railings on the private land are adjacent to a highway and essentially cause a nuisance to the highway. Although the railings are damaged 3 days before the accident by the pedestrian on the highway, and so that wasn't enough time for the occupier in that case to continue the nuisance. And so to that extent, it's transmissible into the realm of public nuisance. Yes, I don't think I need to take the court to Lord Porter's opinion as well, which essentially says the same thing. The crucial point is that continuing a nuisance happens where, if with knowledge or presumed knowledge of its existence, the occupier fails to take reasonable means to bring it to an end when he has ample time to do so, whereas adopting the nuisance is making use of it. And I should say, on the facts of Sedley, Denfield and O'Callaghan, both existed. The culvert that the Trespassing Authority had installed was both made use of by the defendant because they used it to drain their own land, but it was also continued by the defendant because they had been aware of it in the 3 years that intervened between the nuisance event and the installation of the culvert. So both applied in that case. But that goes to my submission that in this case, the highest it can really be put as a matter of law is not that the defendant adopted the nuisance, because the defendant didn't do anything with these poles, didn't make use of them, so it can't be an adoption. The most it can be said is that there was a continuance of the nuisance if the defendant had sufficient time to identify it, a power to abate it, and failed to abate it. And that's what we'll come to. Can I then take the court to the hare that was set running in Gorringe, which is back to tab 9 of the bundle. So that's the authority bundle, of course. As I mentioned earlier, to page 282, which is the speech of Lord Scott. And if I could just please invite the court to read paragraph 51.
Yes.
For context, highways authorities have statutory powers, indeed statutory duties to prevent obstructions on the highway, and so to that extent have duties to remove nuisances. What Lord Scott did at paragraph 51 was, in referring to Sedley Denfield and those powers that the highway authority had, was to say where damage complained of has been caused not by the failure to maintain the highway, but by something done by the highway authority or for which the highway authority have become responsible, liability continues to be governed as a common law, essentially in public nuisance. What Lord Scott was doing there, albeit obiter, was saying that in theory a highway authority could be responsible for continuing on Sedley Denfield lines an obstruction that has been left by anyone on the highway. And we see that again, if I could just go here, at paragraph 76 on page 289, towards the end of Lord Scott's speech. Your Lordships, your Ladyship should see a line, 4 lines down, beginning, in addition, a highway authority may be liable. I would just invite you to read that sentence. So, the court can see the point there. Lord Scott suggesting in an obiter part of his speech that, in theory at least, it was possible for a highway authority to be liable in nuisance for unreasonably failing to abate a danger introduced by a third party. That then sets the scene for the case.
You mentioned a statutory duty to remove obstructions. I haven't seen any reference to that in the passages you've taken us to.
Apologies, my lady. It's section. It is set out in Gorringe. I will try and put my finger on it. In fact, if I may, I can take the court to it in Alley and Bradford because those powers are set out.
I think it's at page 281.
I'm grateful. Thank you. Yes. As I said, they are referred to again in Alley and Bradford, which the court will find at tab 13 of the authority file.
So are you leaving Gorringe now?
Yes, my lord, I am.
Thank you very much.
It's tab 13 of the authorities bundle. Alley and Bradford, 2012, 1 weekly law report 161. Again, the facts are pretty straightforward. It's a highway authority case. It's a member of the public who suffers an accident on the highway. I believe she's walking down some steps on the highway on which there is an accumulation of mud and debris, and so clearly a nuisance, a state of affairs that represents a public nuisance. And she slips on that accumulation of detritus and suffers an injury. And a claim was brought against the highway authority in nuisance. And I would just invite the court to consider, as I mentioned earlier, Lord Justice Tolson's judgment, as he then was, which the court will find at page 390, where his lordship deals with the claim presenting nuisance. That is at paragraph 34 on page 390, overleaf paragraph 40 on page 391. And I would just invite the court to read those paragraphs in full.
Yes. Yes.
The point, my lord, that I make comes out of that is very much confining Sedley Denfield, notwithstanding the obvious remarks of Lord Scott and Gorringe, confining Sedley Denfield to that situation where there is an occupier of land who has control of the nuisance, the power to abate it. That is where the buck stops for the ability of someone to continue a nuisance in my submission. Now, the learned friend says, as he to the learned judge below, that, well, Annie and Bradford is distinguishable because it's a highways case against a highway authority. In my submission, the principles apply with equal, if not more, force in the present case, because, of course, a highway authority has a limited type of ownership of the highway, and Lord Justice Dawson has then once dealt with that. In our case, the London Borough Tower Hamlets didn't own the highway, wasn't an occupier of it. All that can be said is it had a power, a limited power, to remove nuisances that market traders left on the highway. To that extent, it's in the same position as a highways authority with a power to remove nuisances left by third parties. So my essential submission is that Alley and Bradford properly understood closes the door on any suggestion that this defendant was capable of continuing the nuisance left by the market trader.
So do you say it's analogous to this extent that the Act with which we're concerned also provides a complex statutory code governing the obligations of parties?
I do, my lord.
Is that your submission?
It is as well, yes. It's an additional submission, in the sense that in my submission, the primary submission is that this defendant is not an occupier, as is common ground, and doesn't have an unfettered right to abate the nuisance, not in control of the nuisance in that sense. But my subsidiary ground is that the court should not interfere through the back door of nuisance, if I can put it like that, with the regime that Parliament has set up, which includes a limited power to remove this type of nuisance.
This is in the 1990 Private
Correct.
Act.
I would also make this submission that there is an incoherence in the judgment, because assuming, for present purposes in the alternative that the defendant was in theory capable of continuing this nuisance, it would only be taken to continue the nuisance once it has had a reasonable opportunity to identify it and then abate it. And the problem that we have here, and this is a point that I'll come back to in my later grounds of appeal, is that this nuisance was only created at 2:45 p.m. and the accident happened at 5 o'clock.
The judge seems to come at the issue of nuisance on more than one occasion and gives different reasoning.
Yes, my lady's point goes back to the point I made at the beginning of it. It is quite difficult to distill the strands of this judgment. But there is an incoherence there because it can't be right that for the purposes of negligence the defendant was required to, well, the defendant had until 6 o'clock to find this nuisance that was left at 2:45. But for the purposes of nuisance was expected to find it earlier. But this bleeds into my subsequent grounds of appeal really about the inspection regime that the judge found the defendant should have operated and how the failure to operate that regime caused this accident, which I'll come to.
Is section 130 of the Highways Act what you were describing as the duty on the Highway Authority to remove?
Yes, I believe so, my lady. It's one of the sections contains the duty and another contains the power. Forgive me, I can't remember which way round they are, but it's yes. The duty is section 150.
Well, that's the enumeration to specific types, isn't it?
Yeah.
But in any event, the Court of Appeal found no liability founded on either section 130 or 150.
Yes. I think at this juncture I need to deal with the 3 cases relied upon by my learned friend, particularly a case called Dibble, which was the real plank of the claimant's case on this point.
Yes.
To gainsay the submissions that I've made. Dibble, the City of Newcastle, 1993, Personal Injury Quarterly Report, 216, can be found at tab 4 of the bundle. The facts in Dibble are a little more complicated, but I do think we need to look at them. Because this is a case where there was a large site, a large development in Newcastle. Maybe familiar with it, I think the Newcastle Registry is part of the site, called the Quayside. And at the perimeter of the Quayside was a public highway.
Is it near the Blinking Bridge?
I believe so, my lord, although I wouldn't like to check without looking, but it's a large site with there's a public highway on its perimeter. Confusingly, the site is called the Quayside, and the road name for the highway is called the Quayside. But they are distinct sites. A market was run on the Quayside development site every Sunday. That market, or certainly a number of the market stalls, abutted the public highway. Because, as your lordship, your ladyship might envisage, the public highway was closed when the market was in operation, and so people would be milling around the highway as much as the site itself. And the front of some of the stalls, I think there were 180 market stalls, 40 or 50 of which abutted the highway and were contiguous with the highway, and 40 or 50 of those stalls had awnings at the front of their stalls that crossed over onto the highway. So that's the situation in respect of the land and how the land was configured. There were 3 defendant parties here. One was Newcastle, which was responsible for the market that operated on the Quayside site.
But we don't know anything about the terms on which
No, and this is a point that I'm going to come to. One of the difficulties that we have with the case of Dibble is, whilst it's clear that it was found that Newcastle's first defendant was responsible for the site, we don't know what the basis of the responsibility is, whether they were an occupier, for example, of the site. We just simply don't know. So that's the first defendant. The first defendant was an occupier. Sorry, I don't know that. The first defendant had some responsibility, whatever it was, for the quayside site. The second defendant was a contractor that was engaged to set up all of the scaffolding for these 180 market stalls. In contrast to the case before the court today, this was a case where the market had uniform stalls and was provided with uniform stalls and scaffolding. And the third defendant was the individual trader who operated the market stall that caused the nuisance. What that trader did at the end of the day, the scaffolders, having installed a 2.5 foot projection of the scaffold from the quayside onto the highway, the scaffolders then left it like that. That was no problem whilst the market was in operation, because to all intents and purposes it was the same site with people using the highway and the site. The problem arose when the highway was opened and the market had closed, because then we were in a situation where the highway was open to road users and there was a 2.5 foot projection from a scaffold into the highway from the site. The third defendant, market trader, made matters worse when he packed up for the day, because the projection had previously been covered by an awning, but he removed the tarpaulin in the awning and left the scaffold pole projecting.
And he was the market trader.
He market trader, yes. So there are three parties there. We've got the defendant, defendant 1, the Newcastle Council, defendant 2, the scaffolding company that was contracted to provide these stalls, and defendant 3, the market trader. Matters are more complicated because the accident happened when 45 minutes after the market had closed and the highway was open. The claimant was a passenger in a vehicle that was being driven down the highway that struck the pole. It's complicated because the driver of the vehicle was an employee of the First Defendant Council. So there was clearly a claim based on the duty of care that the driver owed to the passenger, for which the council was vicariously liable, for driving into something on the highway negligently. And that was 75% of the fault in this case. What we're concerned about in the present case is the nuisance claim, which represented 25% of the fault. And that was shared by all three of the defendants.
Was it only for D2 and D3? Was it only nuisance?
It may have been negligence as well, my lord, but I can't recall from memory. They were.
He deals first with the.
There was on page 138 of the authorities bundle, the penultimate paragraph from the bottom. There was a finding that
it constituted a nuisance.
yes, the second defendant scaffolders had created it, and the third defendant market trader had perpetuated it.
When you go to the next page, it says what the judge had to do. In this case, was decide to what extent, if at all, some third defendants could be responsible, not only on his findings in creating a nuisance, but also because they were negligent.
Yes, I'm grateful, my lady. It does seem, although we do run into the difficulty where we don't have the first instance judgment. It seems that it was on both bases. The important point for our purposes is the basis upon which Newcastle was found responsible in nuisance for this protruding pole. The closest we get is at page 139. And in fact, I think that's my Lady Justice Yip's quotation that we've just taken to, about halfway down, and this is an extract from the judgment below. The responsibility of the first defendants, the market authority managers, who permitted the market to be run in the way it was, insofar as it constituted nuisance. So there was a suggestion that the basis of the responsibility was the market authorities managers who had some responsibility for running the market. And just above that, at page 139, there's a paragraph that begins, "For my part, it is plain that subsection 2." And then 5 lines down, it says, 7 lines down, "The relationship with the local authority was that Newcastle upon Tyne Council had the overall responsibility for this market, and through their supervising officers, a measure of control of it, no more." So there was clearly a finding below that Newcastle had a responsibility for the market and control of the market, and that is the basis upon which it was found liable, it seems, both in negligence and nuisance.
But there's no discussion at all of the issue that we're debating, whether something constitutes a mere omission, exercise of a power. And it's notable that there isn't a single authority referred to in this case. It's an extemporary judgment with no authority side.
Yes, so my principal submission is if one can't extract from this authority the proposition that learned friend advances, that somehow this generates liability and nuisance. And the two things we do not know, which would be relevant to this, are what Newcastle's status was in the land.
Yep.
Was it an occupier? I think I could go as far to this extent that it wouldn't be surprising if they were an occupier of a developed site like that. And it is a site that is separate from the public highway, so these are two different parcels of land in that sense. And the encroachment was from the quayside development site onto the public highway. So in that sense, we're different to the present facts, where it's all on the highway.
Well, they may have owned the land.
They may have owned the land.
They may have been occupiers.
They may have been occupied. We simply don't know.
And if they were either of those or neither, we don't know the terms on which they were, as it is said, responsible. We don't know why they were responsible.
No, we don't. We can only speculate. But speculation is, of course, not a reliable ground on which to extend the law of nuisance, as is contended. The second point of law that we don't know is the point I made, that unlike this market in Whitechapel, where, this is my way of putting it, but where it was bring your own equipment, this market, it seems that Newcastle were providing, through the scaffolders, were providing the market stalls. And so it seems to me in those circumstances, it's not beyond the realm of possibility that where one is providing the traders with uniform scaffolding equipment, it seems to me there may be a responsibility there for setting the scaffold up in a way that doesn't create a nuisance.
How would that work if they provided a template scaffold to do it, which projected by design 2 foot into over the highway? Then they might have a responsibility for that.
Who knows? So, I mean, really where this all goes is to my submission that what may have seen from the skeletons below and the judgment that Dibble was the real plank upon which the claimant put her case. That there is possibility that it's possible for there to be liability and nuisance. But my submission is that we can't draw any conclusions from Dibble. Certainly not conclusions that sustain a holding that there is a cause of action available in public nuisance simply from on the part of a regulator of a market exercising a statutory function. We simply can't make that draw that distinction. I don't intend, I'm conscious of that Malone Friend will address the court, I'm sure, on Tipple, but I don't intend to say any further on that at this stage, unless there's anything I can assist with on that front.
No.
Two further cases relied upon by the claimant, Lipiat and South Gloucestershire County Council 2008 Queen's Bench Report 51, which is at tab 5. I'll leave it to Malone Friend to address the court on this in detail, but this is simply a case where the defendant local authority occupied a strip of land next to a farm. Sorry, owned a strip of land next to a farm.
So sorry, which case?
Apologies, Lord, it's Lipiat,
Lipiat,
South
number
Gloucestershire,
5.
tab
Yes.
5.
Right, thank you.
The facts are relatively straightforward. The local authority owned this strip of land next to a farm. Over time, travellers started to occupy the local authority's strip of land. The local authority, as it happens, went a little bit further than passively tolerating the presence of the travellers. They installed toilet facilities, they installed a skip, they installed water bowsers and things. So they had some role of assisting the travelling community that had set up campers, as it were, on this strip of land with their occupation of the land. What members of that community then did was go from the council strip of land onto the farm and commit various acts of vandalism and antisocial behaviour. So this is a classic nuisance case almost. It's a case where there is an emanation from land owned by the council onto neighbouring land. I should say this was an appeal against strikeout. And so the most that comes out of Lipiat is that it was arguable that the travellers who moved from the council land onto the farm were the emanation, were the nuisance that went from the council land to the adjoining land. There isn't actually a conclusion that was definitely a nuisance. It was just that it was arguable that it was. But either way, all we have here is a case where there is an emanation from land owned by a local authority of a nuisance, being the travellers and the acts that they did on neighbouring land. I mean,
In the 19th century, it was cases about prostitutes, wasn't it?
yes, well, there are some references to those cases in
I
these
confess
decisions.
I have not read Lipiat before coming into court.
No.
But that's the reason why no one could argue with the basic proposition that the escape of travellers could amount to a nuisance.
Yes, exactly. The only factor that makes it slightly unusual is that it was people rather than tree roots or whatever it may be. But that people were, in theory at least, capable of being an emanation.
Dorset Yacht wasn't decided on the basis that it was a nuisance, was it?
No.
Because it wasn't from Home Office land.
Home Office didn't own or occupy Brownsea Island.
Thank you.
So I'm not going to go look at in any more detail, having distinguished this in that sense. The final case, which the court find at tab 8, is Ellie Jones and Portsmouth County Council, 2003, 1 Weekly Law Reports 427.
This is trees.
This is the tree roots. And at its heart, it is another classic example of a private nuisance. It's trees on highway land that encroached onto adjoining property of the claimants and caused subsidence. The principle that comes out of Ellie Jones and Portsmouth is the Highway Authority was not sued. Portsmouth County Council was sued, and they were essentially the Highway Authority's contractor. And they had, due to that contract, a significant degree of control over those trees. There may not need to be any need to turn it up, but at page 259, the court will see descriptions of the maintenance that the local authority provided in respect of the trees, which included a plan to reduce the growth of tree roots by reducing the crown of the trees and so on. And that was not only that was their right and their obligation to do that. And so all that comes out of Ellie Jones is almost a slight departure from most of these cases where it's the occupier or the owner. But the reason for that departure is because essentially the local authority Portsmouth, in being the contractor responsible for the tree roots and having what I would say is active control over the growth of those tree roots, they essentially had occupational control over the trees. They had specific control over the very thing that emanated, which is the tree roots. Now, the claimant in this case tries to extract from that the proposition, well, the defendant, Tower Hamlets, had control over the market traders, as though equating the market traders to the control that Portsmouth had over the tree roots, which, in my submission, is erroneous. So I don't intend to say anything further on that, and as I say, I'm conscious of the fact that the claimant will, and my learned firm will address the court on those cases tomorrow. With that, then, that is everything that I intended to say on ground one.
Yes.
Unless there's anything arising that I can assist with on ground one, I can move to the quicker grounds.
Right. Grounds 2 to 4.
Ground 2 to 4.
Half an hour in toto, you said. Right.
Let's see. So this is a challenge. Ground 2 is a challenge to the learned judge's finding of fact that these poles had been deposited on the highway at 2:45, such that they were there to be seen on inspection.
No later than 2:45.
No later than 2:45. Yes.
No later than 2.
I think that we have to take from that in our submission that it's 2:45. It's the finding from when the defendant, if you like, would be on notice to discover them.
He actually, I think, said something inconsistent about that, because I think he then said it's highly likely that it was
Much longer.
much longer than that. And
He
it's
did.
highly likely then on about probabilities it's much sooner.
Well, my lady, my submission is that the finding is 2:45. He I think he goes as far as there. Well, maybe we need to turn it up.
Yes, please.
It's back to the core bundle. I believe it's page 131. Paragraph 258. The judge, that's an appropriate juncture to go to this paragraph anyway. The judge sets out the basis of his finding that the poles have been there from at least the start of the late shift, i.e. from 2:45. And if I could just say at this stage, it seems the judge takes into account two parts of the evidence to make that finding. One, Mr. Udin, who was one of the defendant's witnesses, his statement that traders left early. So the judge took into account Mr. Udin's evidence that traders would leave earlier than close of market time at this time of year. And then the second matter he takes into account is the absence of an inspection from 2:45. As the court will probably recall earlier, it seems that there was no one there from 3 to 3:30 at the latest. No one from the defendant. So for those reasons, the judge appears to be finding that the poles arrived, were there from at least the start of the late shift. Then at paragraph 259, the learned judge says, although this does not affect my decision on breach of duty, I do consider it highly likely, given that they were in a gap between two market stalls, and given that they were adjacent to a bin, such that they may be regarded as rubbish, that they have been there much longer. But it is not necessary for the court to reach that conclusion. So in my submission, the judge isn't making a conclusion they had been there for longer. His conclusion is, for these purposes, that they were there by 2:45. Now, the claimant says, well, essentially the judge was entitled to make that factual finding on the evidence. And familiar authorities are put before the court on essentially the standard of review that the appellate court should take when an appellant seeks to impeach findings of fact. Essentially, that unless the appellate court can be satisfied that the judge was plainly wrong, the appeal, it's not at large for the Court of Appeal to interfere. In my submission, the ground raises a slightly different point. It is not that the judge was resolving conflicts of fact and making the finding that he did. It is that in my submission, for the reasons I'll go on to make, there just simply was not the basis in the evidence for the judge to find whether they were there at 2:45, 3:45, 12 o'clock, whatever. There was just no basis in the evidence for that conclusion, and that's a distinction I draw.
Or therefore he was plainly wrong.
Or therefore he was plainly wrong. Yes, I'm very familiar. Now, I will just take the court to McGrady and McGrady 2013 1.
Before you do that, just still looking at page 131.
Yes, my lord.
I don't really understand it. The judge found, and was entitled to find, indeed it's almost common sense, that some traders leave early depending on the weather. It gets dark at 4 o'clock.
Yes.
Seems likely that poles were left there by the guilty trader, whoever it was, who dismantled his or her trolley and packed up and went home.
Yes.
It wasn't, there was no evidence that an inspector looked at that part of the market on the late shift, but I don't follow why that supports the conclusion that the poles must have been there at 2:45.
Yes, well, that's very much my the two bases on which the judge makes the finding are, one, Mr. Udin's statement that the traders left early, and I'll come back to that.
Yes.
Because it's important the court sees the evidence, and it was being put to Mr. Udin that they may have been leaving at 4 o'clock, around the time of 4 o'clock. So I'll come back to that. But the second point is that the judge is making that positive finding of fact about when they were left there based on the fact that no inspection was carried out. And that, as a negative can't prove a positive, is essentially my submission. Where this would have been relevant is some of the defendant's witnesses, in fact both of the defendant's witnesses, happened, as I mentioned earlier, to be there on the day as part of this wider operation until they left between 3 and 3:30. And so, if the court was confronted with a situation in which witnesses for the claimant were saying these poles have been there since 2:45 or whatever it may be, and the defendant's witnesses were saying, well, no, they're not. No, they weren't. They weren't there when we were on the market. Then I could see that the judge could permissibly reject the evidence from the defendant's witnesses and prefer the positive evidence from the claimant about when the poles were there. But in my submission, it's not permissible to find from the evidence that there was no inspection that the poles must have been there
Well, at a particular time.
at a particular time.
They were there at 5 o'clock when the claimant suffered her accident. No,
Yes, of
no
course.
dispute about that.
No.
You might have relied on the absence of an inspection to say it wasn't before 14:45, but to say they must have been there by 14:45 is getting it the wrong way around.
Yes,
That's your point, isn't it?
it is. That's exactly the point. Yes. The second point then is Mr. Udin's evidence. And the court will find that in the transcript at page 299 of the supplementary bundle.
Did you say 299?
Yes, my lord.
Thank you.
If I could begin halfway down the page, question is put to Mr. Udin by my learned friend. As you said in your statement, the time at which this happened, so 5 o'clock or thereabouts, is a time that your knowledge is that people start packing up things. And that could start to take place earlier in December because it gets dark early in December. So, of course, the witness evidence is that the market closes at 6 o'clock, but the witnesses accepted that in late December, traders will pack up earlier.
Yeah.
No doubt for sensible reasons. And so Mr. Udin was being cross-examined on his reference to people packing things up at 5 o'clock. Which was, of course, an hour earlier than formal close of the market. Mr. Udin accepts that, and then the next question is, so that could start to happen from around 4 o'clock, could it not? Essentially, Mr. Udin accepts that. And that, as I mentioned earlier, dovetails with the judge's judicial notice that he took about the fact that the sun set just before 4 o'clock. And then the final question that I take the court to is the question that was then put to Mr. Udin. And on a dark December evening, which we know from the claimant's report, is the ground was wet, so it may have been raining that day. That might be a day people pack up early. Mr. Udin says yes. And so all that Mr. Udin's evidence did was to accept that people might have been packing up early at 5 o'clock or as early as 4 o'clock. But the judge has taken that evidence to support a finding that the poles being left there as part of the operation being packed up would have been there from 2:45. And so, in essence, my submission is that the judge, that Mr. Udin's evidence did not go as far as the judge said it did. I think I was going to take the court just to one authority on this, which is the McCready decision, which the court will find.
What are you after?
Apologies, I'm looking for McCready or McCready.
Page 417.
I'm grateful to my lady. My lady's ahead of me.
Tab 50.
we could perhaps turn to page 420. This is where the Supreme Court deals with the plainly wrong test. And just above, well, in fact, in paragraph 1, the Supreme Court quotes from the case Thomas and Thomas, 1947, appeal cases 484, which sets out essentially how at large factual findings are to be impugned on appeal. And I would just draw the court's attention to number 3, proposition number 3. The appellate court, either because the reasons given by the judge are not satisfactory, or because it is unmistakably so, appears from the evidence, may be satisfied that he has not taken proper advantage of his having seen and heard the witnesses, and the matter will then become at large for the appellate court. And then the authority goes on to deal with situations in which the question of law arises about whether there was evidence upon which the judge's factual finding could be sustained. That is dealt with, for example, at page 427. In another quote from Thomas and Thomas, if there is no evidence to support a particular conclusion, and this is really a question of law, the appellate court will not hesitate so to decide. That's, should have said at paragraph 27.
Yes.
And so
There's nothing in paragraphs 1 to 6 of McGrady and McGrady which isn't pretty familiar to anyone who's sat in any court, either in England or in Scotland.
I don't intend to spend any more time on it, save to simply note the point, an obvious point, that if this court is satisfied that there just simply was not the evidence before the judge to sustain his finding about when the poles were left there, then this court can interfere. And essentially my submission is that there was no evidence upon which the judge could make that finding, that the two features of the evidence that he relied upon can be impeached, the reasons I've given, and that this was simply a case where the claimant couldn't prove on the evidence, as was her burden, when the poles were there.
We touched earlier on paragraph 259, where he says it's highly likely. It's longer. Your submission is simply more of the same.
Yeah, it's more of the same, Lord, exactly, yes. I mean, my primary submission is that the judge wasn't making a finding, he was speculating at that stage. He wasn't making a finding on the evidence. But if he was, and the court's against me on that, then it's exactly the same point.
Yeah, thank you.
I should say, before I leave this ground, that the court did have before it essentially hearsay evidence from a lady called Miss Haddadi, who was one of the market traders operating from the pitch at number 68, which was adjacent to this location. Miss Haddadi did not attend court, and indeed her statement was taken at a time where she was being considered by the
It was
claimant.
being suggested that she was the responsible person.
Yes. Now, I'm not going to take the court to that evidence because the judge quite properly discounted it, and in fact said.
Did he discount it? He said he applied little weight to it.
He said he applied little weight to it.
He didn't say he discounted it altogether.
Well, it's a little confusing, perhaps. At paragraph 234. On page 126. The learned judge said 234, I can only give very limited weight to her statement. But then at paragraph 236 says, I do not, however, infer from that the trolley had been abandoned for some time. So it seems to me, on reading paragraphs 234 to 236, that the judge is not accepting her evidence that the trolley had been abandoned for some time. There were, it has to be said, issues that actually intended to give evidence, I would have explored in cross-examination. Not least where this trolley she's talking about was said to be abandoned, whether it's the same trolley that caused the claimant's accident. She referred to the trolley as having broken wheels. And where on the market it had been abandoned. It certainly wasn't clear from her evidence that she was saying it was in the same place. But in my submission, reading paragraph 236, the judge is essentially rejecting that evidence, but then importantly, when the judge gives his reasons, as we've just been looking at paragraph 257 and 258, he doesn't make any mention to her evidence at all. Well, in fact, he does say it on page 131 at 257.6 that he's put little weight on this her daddy's evidence. That's roughly in the middle of paragraph 257.6.
Little weight on.
So in my submission, it can't be clearly said that he is deciding this issue based on her evidence. All of the indications are that he is discounting it.
Is there any significance of the findings at the beginning of paragraph 238? Mr. Gooding, who seems paragraph 235, was asked about the incident years after it had taken place. Anyway, he added, Mr. Serduk's shift finished at 4 p.m. There was no officer on the late shift. This means that there's no one carrying out the activities of the late officer, covering broadly, making sure that things are packed up properly.
Yes. So essentially, if there had been evidence from the claimant that the poles were put there when the judge found that they were, then all of that would have been relevant because that would have entitled the judge at first instance to say, well, I'm rejecting the defendant's positive evidence that they were not there because, as he found, they would have been distracted whilst they were carrying out this operation, and as it happened, there was no late officer there from 4 o'clock in any event. So all of that would have entitled the judge to discount any reliance on the defendant's evidence insofar as it could help with the question about when the poles were there. But in my submission, it really, even if the defendant's evidence counted for nothing, it's still for the claimant to prove when the poles were put there, and in my submission, there was no evidence by which she could do so. And unless I can assist any further on ground 2, I'll move to grounds 3 and 4.
Yes.
Ground 3 is a challenge to the learned judge's conclusion that the defendant was required to inspect and thereafter remove these obstructions before the end of the day. And we looked earlier at the statutory power in section 35 of the 1990 Act. And the simple submission here is that the judge ignored the statutory context and essentially, in so finding that the defendant was in breach, required the defendant to undertake a removal that it wasn't lawfully entitled to do.
Can you just take us back to the provision?
Yes, well, it's tab 1 of the authority file. And it's page 17, the very bottom of page 17.
Well, what about this? cessation of trading on any day, line 2 of section 35(1). Yes.
Yes, my lord.
Now, the fact that the poles were sitting there means that that trader had ceased trading.
Yes.
And so there is a question of interpretation of
Yes,
section
I can see.
35 of whether it only applies when everybody's ceased trading, which is a fairly odd thing to decide. Because the vice that this is getting at is people who pack up and leave stuff lying around.
Yes.
But they don't. But it's not meant to authorise the council to go and take down people's existing stalls and things like that.
Yeah.
So the suggestion on that basis would be that there was a power in given the situation as shown in the photographs, whether or not everybody else had packed up, there was a power to remove the poles.
Yes.
Is that right?
Well, I put the form of construction on it that it's referring to the market cessation of trading at the market is how I read that.
Yeah. But it
Because of course the difficulty would be then the defendant would be required to identify which trader had ceased trading at which time.
well, no, you wouldn't, because that's where I started. The fact that the poles are sitting lying in a stillage in the afternoon, so they're clearly not there preparatory to being built into the stall, suggests that the trader is at any rate is not trading by the time they're in that position.
Yeah.
And I agree with you that it's not absolutely slam dunk unambiguous just on the words, and you're writing in some words, and maybe I am too, but it would be a more extreme interpretation to say that absolutely everybody in the market has to have ceased trading before anybody can remove anything.
It would be very strange, wouldn't it? I mean, it's a large market by 4:30 on a December day. Most traders, let's say, packed up and gone, but one is valiantly soldiering on in one corner of the market. And this section says it shall be lawful for the council to remove stuff lying around, even if one trader is valiantly soldiering on in one corner of the market. I appreciate you. The heart of your case is saying it may be lawful, but it doesn't amount to a positive duty to remove.
Yeah.
I
suppose, and on that construction, it would be a factor that would go into the standard of care, whether the defendant was being required to carry out inspections and then identify whether it was lawful within the terms of section 35 so construed for it to remove the items. Yeah. I certainly see that point, my lord. Unhelpfully, trading is not defined in the earlier in section 21. Street trading is. Street trading licenses. So that gives us some insight into trading, but I can see the points open for
Well, that makes sense, doesn't it? Because street trading is that paragraph in a street.
Yes.
So trading means, as you would expect, selling or exposing or offering sale for things. So someone's still running their store.
Yeah.
That's not a showstopper.
Yes.
All right. Anything more on ground 3 and or ground 4?
Just ground 4 then, my lord, if I may.
Yes.
It's again, I think we just need to go back to the judgment for the final time from me at least, at page 133. the court will see paragraph 267 and paragraph 268. I could begin at 268. The judge's finding on the standard of care is that, withholding on the standard of care, I should say, is that the defendant should have ensured that there were no obstructions in and around the market, including in the area between the two stalls where the claimant was injured, once in each of those time periods, but not as frequently as hourly, it being the claimant's case at trial that the defendant should have been inspecting hourly. The time periods are provided above. The one that we're concerned with for these purposes is 2:45 to 6 o'clock. And so it has to follow, as a matter of logic, that the defendant was not in breach of duty on this standard until 6 o'clock.
Well, it could be the other way around. For all we know, there was an inspection at 3 o'clock.
Then they wouldn't be in breach. If that had been the case.
Yes.
There wasn't.
So the finding, if the findings he was there, the polls were there at 2:45, and they'd have missed the polls.
Yes.
Now the breach is found.
You're treating it like a contractual delivery term that did, by a term of a contract, says you've got to deliver it, your oats or whatever it may be, by Tuesday, and someone jumps the gun on Monday. You're not yet in breach because you haven't got to Tuesday.
Yes, I think that's right, Rod. The point that I make is that in personal injury, where breaches are failing to inspect, I mean the Highways Act claims are a classic example. It's not a perfect analogy because it's a statutory defence, but say an occupier's claim where there's a pothole or a danger on occupied land, the occupier will be held to a certain inspection regime.
Yeah.
And in my submission, when one looks at paragraphs 267 and 268, the inspection regime that the defendant was being held to was to inspect once between 2:45 and 6 o'clock. Now that could have been at 2:46, it could have been at 5:59. Doesn't matter, and that reflects the reality. And I suspect that's why the judge didn't accede to the submission that they should be hourly inspections, perhaps as one might expect to find in a salubrious toilet of a nightclub, where people inspect the toilet facilities every hour or whatever it may be. These are all matters of fact of degree, depending on the particular land that is occupied. But in this case, the standard was no doubt reflecting the duties that the market officers had to attend to, which was not just looking for obstructions, dealing with all of the other 180 markets, was that they needed to inspect this area at one time between 2:45 and 6.
But the findings of fact 272 and 273 are findings which the judge was entitled to make.
Well, in my
With
submission,
no inspection from at least 2:45, leaving a period of just over 2 hours prior to the accident with no inspection.
yes, and that was essentially common ground that there was no inspection. But that isn't the finding of breach. That's the factual finding.
Yeah.
No inspection took place. The finding of breach comes at paragraph 280. Well, it's the cause of breach at 283 on page 135. It's the final sentence, paragraph 283. The failure to abide by the frequency of inspection for obstructions that I have found was appropriate, i.e., I read in here, one inspection between 2:45 and 6 o'clock, and concomitant with the defendant's duty of care, caused the claimant's injury. And my respectful submission is that simply cannot stand to reason, because the defendant wasn't in breach at 5 o'clock. It had until 6 o'clock to identify the obstruction.
So there was no late shift officer
Yes.
on the judge's findings. And
Yes.
after 5 o'clock, everybody's gone.
Yes.
Right, is that ground 4?
That is ground 4. It's safe to say that the judge's findings, whatever they were on breach and causation, is also relevant to the nuisance cause of action, the pure nuisance cause of action, because if this defendant was capable of continuing the nuisance, it had to have a reasonable opportunity to identify it and then remove it. And that is essentially what the negligence claims speak to, or the standard of care is speaking to. With that, unless I can assist any further, those are my submissions.
Thank you very much, Mr. Hetman. Mr. Coffey.
My lords, my lady. Looking at the time that is left in the afternoon, I suspect I will get a certain distance and no further.
Yes.
And how I intend to use that is, given that I suspect a lot of time is likely to be spent on the negligence aspect, I will leave that to tomorrow with your leave, and instead I will address some preliminary matters to which I'd like to draw your attention in the factual evidence bundles, followed by dealing with the nuisance aspect, and I suspect that may take me to the end of the day with your leave.
Right, that's fine.
In terms of the factual aspects that I wish to call up, my learned friend Mr. Hedgeman has helpfully opened the evidence and the factual background to this, and there's little I feel I could usefully add in that regard. But I do wish to bring you to certain aspects of the 1990 Act, if I may. This is the first tab of authority. The sections that I wish to highlight here relate to the designation of the licensing streets. So this is section 24, which appears at page 6 of the bundle. And Mr. Hedgeman has alluded to this already, but in
Sorry, my hearing is
I'm,
not good. Where are
Page
you?
6.
I'm so sorry, page 6 of the bundle, my lord.
Section 24.
Thank you.
Section 24.
Thank you.
This is in essence the power of the appellant to designate streets or areas within their local authority area as licensed or licensing streets. This is the first step in the chain in designating Whitechapel Market as an area in which street traders are permitted to trade and are licensed to trade. And the respondent says the first stage in the act of licensing that market and controlling it. The manner in which this is worded is a discretion. It's if a borough council considers a street trading should be licensed in their area, they may from time to time, and then it passes the relative resolutions thereafter. It is not that they shall designate streets as being licensed streets, it's that they may. It follows from that the licensing regime comes into play, and this is where section 23 comes in, and that is it's unlawful for a person to trade in a licensed street without a license. A linked provision which appears at page 18 is section 35.
Yes.
This section makes it an offence for an individual to either trade in a licensed street without a license or to street trade in other areas within the borough. So in essence, the designation of the licensed street and thereafter the licensing of the street is what creates the ability for traders to engage in market trading in Whitechapel Market. In due course, and likely tomorrow, I will come on to the submission that this is in essence the beginning of the continuing act of the designation, licensing, management and control of Whitechapel Market and those who engage in street trading within that market. And it is this that we say an aspect of which was conducted negligently, and we say that is the aspect the judge identified in respect of the inspection regime not being carried out as it should have been, and it is that continuum that creates the liability and negligence.
Whitechapel Market's an ancient market, quite an ancient market. Do we know whether it was designated as a licensed street under the 1990 Act or one of the Schedule 2 provisions?
We don't know that. I don't know that.
We don't know that. It's not in evidence.
It's something I can look into overnight if it's felt to be necessary. The simple submission, however, is that under the current regime, as of the 1990 Act, because that is where the powers are derived from in this particular case, absent the local authority designating Whitechapel Market as a licensed street trading would not be permissible there. Have I understood my lordship's question correctly, or is there anything further?
I think so. It's just when you turn the page, there's provision, I think, for streets which have been designated in some way or another. There's a reference to Schedule 2, which is all the which we have at page 23. And they go back a good long time. And I'm not doubting what you say, but on my reading of the Act, there may not have been a formal designation under the 1990 Act because it was already a relevant street. But if we don't know the answer to that, we can't take it any further.
It's not been brought to my attention that it wasn't, if I may put it that way, or that it was. I simply don't have the knowledge in respect to that. I can look into it overnight. I think
it's unlikely that the case is going to turn on it.
I'm grateful for the indication, my lord.
If I change my mind, I'll tell you. Or if we change our mind,
Meanwhile,
we will tell you.
press on. Yes.
Grateful, my lord. Those are the only additional aspects to the Act that I wanted to draw my lordship's and my ladyship's attention to.
Yes.
My learned friend has engaged in the section 35 point, and my lordship has raised some points about that. Additional to that, I would like to take the court to the conditions, the licensing conditions, which appear in the supplementary bundle. They are an exhibit to Mr. Patchell's statement. It is exhibit 4, and they begin at page 87.
Yes.
These are the regulations that are made under section 27 of the Act, and the beg your pardon, the conditions, and the conditions that must be agreed to by street traders if they are to engage in trading in Whitechapel Market. You were taken to condition 3.13. The condition I wish to take my lordship to is condition 13.3. So the reverse of that, it appears at page 99. And this is under the section designated stall/receptacle. And it states that license holders are required to ensure that the goods they sell and those which are connected with their stall and any article or receptacle used for storing or displaying them are kept within the pitch limits at all times, except during immediate restocking. They must also ensure that no food is displayed or stored below a reasonable height, currently 45.5 centimetres from ground level. Now, the reason this is important, in addition to the 3.13 to which my learned friend took the court, is that this does specifically designate that receptacles must be kept within the pitch limits. A point my learned friend made that was not included in 3.13.
And it's common ground, isn't it? That the poles are at least part of a receptacle. They
Was
fall within
agreed
the
at,
definition of
it was
receptacle.
agreed at first instance, and it appears in the judgment that they were a market trader's stall or of some description, my lord, yes.
And so they fall within the definition of receptacle.
Yes.
Thank you.
Again, my learned friend took you to condition 17.2 at page 103. And here is where we differ in respect of our interpretation of the seizure powers that are there. The court will recall this is where the counsel does not prosecute in the courts any person who contravenes any of the conditions in their licence may be subject to one of the following penalties. And the third down is seizure of goods or other materials. In my submission, my lordships, my ladyship, that is sufficient to encompass the receptacles which would be kept outside or which would be left outside of a pitch. In due course, if it's a point that needs to be made further, you will note from the judgment below that these were aspects of the defendant's powers that were supported by the defendant's own witnesses' evidence in respect of what they could and could not do in terms of the removal of items that had been left around the market even before the cessation of trading. Again, in 13.3 and in 17.2, there is no indication that this must only take place at the cessation, or can only be exercised at the cessation of trading. This is a power which is made under the Primary Act and a condition to which all of the market users agree. And in my short submission, that is the power, in addition to the point the bench has made in respect of section 35, with which the items could have been removed.
It's quite odd wording to my eyes. Where the counsel does not prosecute in the courts any person who contravenes any of the conditions in there, who contravenes any of the conditions in their license, maybe, is that their license may be subject to one of the following penalties in their license?
As I read it, my lordship, a comma should be interposed after may, if I can put it that way.
Comma after?
No, I beg your pardon, a comma before may is as I would read it. So, where the counsel does not prosecute in the courts any person who contravenes any of the conditions in their license, may I see the issue. May be subject. Reading the condition as a whole, it must be the trader that would be subject to one of the penalties. A license could not.
But then, forgive me for niggling away at this. It's quite odd. We've got an example in the evidence of a penalty notice being implied, which is then reduced from 50 quid to 10 quid or something like that. So one can understand a situation where they say, but really, seizure of goods and other materials because, for example, you're just outside your pitch, or you can't just seize someone's livelihood, can you?
Well, again, and this case is the prime example. it would create the power that would allow the market to be regulated in accordance with the conditions that are set out, which includes, as my Lord Stuart-Smith pointed out, the health and safety condition in order to keep the areas clear of obstructions, etc. And if that's not being abided by and those conditions are breached, it's a manner in which that can be rectified by the defendant's agents.
Seizure of other materials.
Yes, well, the seizure of the materials that are left lying around or creating a hazard.
Maybe.
Right.
Thank you.
Are we done with 13.3?
We are, my lord. Turning then to the standard operating procedures to which my learned friend referred. These are of particular relevance. They begin at page 122 of the bundle. Again, an exhibit to Mr. Hatchell's witness statement. These are the procedures that the defendant's markets officers are required to follow in their conduct, control and management of the market. The particularly important aspects here relate to, first of all, the timings, but then the duties that must take place during those timings. You see the market designated on page 123 is the Whitechapel Market. The first line is the officer on site or on the market at 08:30, so this is Monday to Friday, and then the duties that that follow thereunder. The particular relevant one is 7 items down. Ensure no abandoned items on footways, bus stops, and crossing clearings. Thereafter, there's Officer 2 is the next one down, and in parentheses thereafter is depending on staffing levels and availability. This was a point that was particularly raised in the court below, that there are a number of these entries that are qualified by that, depending on staffing levels and availability, and a number that aren't. And the plain interpretation of what that SOP means is that unless it's so qualified, it's an officer would be expected to be on site on a daily basis, or more. The next below has the officer on site from 8 to 9 AM. And again, you see 4 bullet points from the bottom: due to ensure all unused items, rigs, boxes, trolleys, crates are removed from the market area and clear access maintained to crossings, bus stops, social spaces, clear of items. The next officer is one of those listed on site from 9 AM to 10:40, depending on staffing levels. As is the next officer, 10:45 till 11:15, depending on staffing levels. On page 127, we have the officer on site from 11:15 till 12:30, not qualified as being depending on staffing levels. And 6 bullet points down: to ensure ongoing compliance with license conditions, containment of waste, etc. The next officer down on site from 12:30 till 12:45. And then there's a second officer from 12:45 till 2:15. The late officer, bottom of page 128, from on site 2:15 till 3:30, dependent on how many officers are on duty at other market priorities. So again, that's a qualified one. And then the officer relevant for this particular claim was on the following page 129, officers on site 2:45 to 1800 to ensure ongoing compliance of license conditions, containment of waste, etc. And that's the 5th bullet point down. So in essence, setting out the duties that these officers have to patrol the market area, ensure that the conditions are met, and indeed the times at which this needs to take place. That, the defendant said, the claimant said at first instance, combined with the conditions, demonstrate the level of control, management and supervision that the defendant exercised over the market traders in that market area, combined with the fact that under the Act, those traders could not trade and engage in that activity in Whitechapel Market without being licensed duly by the local authority. So the submission will be in due course that it is the very existence of Whitechapel Market as it currently exists, if I can put it that way, in response to my Lord Justice Stuart-Smith's comment. The market as it is currently constituted, the only reason in which it can currently exist is with the imprimatur and the decision of the defendant, and the management is a continuum relation to that existence, and that includes the failure to abide with their own standard operating procedures, as has been seen. But it's perhaps a point that I can more
There's
readily.
about 4 or 5 points in that submission, but can I just pick up on one of them? So your submission on the SOP
Yes.
is that while some of these entries can be read simply as regulating or supervising the stall holders, others cannot. For example, there's the thing about removal of waste, which is clearly being undertaken on a market-wide range, I think you would say. And you would say that goes beyond simply regulating by license conditions and ensuring license conditions are maintained.
As part of the license conditions, it is the defendant local authority that's responsible for waste management. And that's where that comes from. And that all features part of the regulation of the market, because that again is included in the conditions where the waste must be left for collection, the cooperation of the market traders with the defendant in order to allow that to happen, etc. So again, it's all of a piece with that high level of control over the market. This is not the simple licensing to say a street trader may pitch up on the street outside and they can sell their wares there, and that's the end of it. This is a highly complicated regulatory framework that says you may not trade in the borough unless you are licensed by the defendant. You may not trade anywhere other than the licensed streets that we have designated, Whitechapel Market being one. And when you do so on our terms and subject yourself to the inspection, management and control of the defendant's officers.
Could we just, forgive me for taking your time, but could we just look at what the license conditions say about waste, just so I'm sure?
Waste management is dealt with at (14) of the conditions, and that appears on
14.
page 100 of the authority, I beg your pardon, supplementary bundle.
Thank you.
So again, this is the management oversight level of control about which we are with which we are dealing in this regard. those are simply the, if I may put it, primary materials that I wish to additionally take my lords and my lady to in advance of my substantive submissions. As I indicated, I propose to begin those substantive submissions in respect of the nuisance, which I may term as ground 1C on the appellant's grounds of appeal. Again, turning up paragraph 180 of the judgment below, with which this was dealt with. This is page 113 of the core bundle.
$200.
113, and it begins at paragraph 180.
Thank you.
The judge's reasoning then continues down to 190. The court is, I think, familiar with that from my learned friend's submissions. But in essence, the reasoning is this, that by virtue of the level of management and control that was exercised over the market within the market and the manner in which the market was run, the defendant was in a position akin to the occupier in a more classic nuisance case. So again, as my learned friend would have put it, in respect of the L.E. Jones case and the Portsmouth Council being in the position of of almost occupation in terms of the level of control that they exercised over the trees. Again, in this case, the market authority had the powers and indeed the resources to patrol the market, to identify breaches of conditions and to rectify those breaches of conditions, including those which created a health and safety hazard or a nuisance to those using the adjacent highway. And in doing so, this is the thrust of the reasoning behind the judge's finding here. That control is sufficient on the basis of Lord Justice, as he then was, Dyson's ruling in L.E. Jones. That is sufficient to engage nuisance in this case. In terms of the continuance of the nuisance, and again, perhaps starting where my learned friend started with the case of Sedley Denfield, hearing at paragraph 2 of the bundle.
Are you going to take us to the L.E. Jones case?
I am in due
Afterwards,
course,
yeah,
my lady,
thank you,
yes,
thank you.
yes. But I first wanted to set out in summary the rationale and then go
That's
through.
fine, I wasn't sure if you were moving away from
No,
that.
no, my lady. So this will be in the first volume behind tab 2. And it's just the definitions of the continuance of a nuisance to which I wish to return. And the ones in particular that I'm looking at, first of all, will be Viscount Malm's definition, which appears at page 41. This appears at the bottom paragraph of the page, beginning, in my opinion. In my opinion, an occupier of land continues a nuisance if, with knowledge or presumed knowledge of its existence, he fails to take reasonable means to bring it to an end with ample time to do so. And then he goes on to the point that my learned friend makes about adopts. I don't dispute that in essence here this is dealing with the continuance of a nuisance rather than the adoption of a nuisance. Using the definition that is set out there, there clearly is no attempt or no evidence of use by the defendant of the nuisance that has been created. So it is a continuance that is being dealt with here. But it is the knowledge or presumed knowledge to which I wanted to draw attention in that passage. Similarly, at page 51, and this is Lord Wright's again, bottom of page 51, final paragraph. And here the knowledge requirement is slightly different. It's knowledge or means of knowledge that he knew or ought to have known of the nuisance at the time to correct it and obviate its mischievous effects. So again, the only difference between the legal principle there that I draw to that which my learned friend drew your attention to is the knowledge aspect, and it is either the knowledge or means of knowledge or knew or ought to have known aspect. The other aspect of Sedley-Denfield on which I will rely if necessary is the point about read across from decisions in private nuisance to public nuisance and vice versa. I don't understand that my learned friend challenges the judge's finding on an impermissible read across of the principle in L.E. Jones, which was a private nuisance case, into what is in essence here a public nuisance case. However, I say there is ample evidence both in Sedley-Denfield and indeed in Lippiat to say that this is something that can take place, often does take place, and indeed the rationale behind it can be seen at page 65 of the bundle. And this isn't the decision of Lord, or the judgment of Lord Porter, speech of Lord Porter, I beg your pardon. It's the second paragraph down on the page.
But it is said.
But it is said, my lord, yes.
Yeah.
Again, the point here is that that distinction between public and private nuisance becomes less relevant, if I may put it that way, when the public nuisance is used as a cause of action by an individual to sue on the special damage that they have suffered as a result. And I say the authority in Sedley-Denfield is sufficient to allow the read across. But again, and we will come to it in due course, in respect of the Lippiat case, it's something that is seen throughout the course of the jurisprudence in public and private nuisance, and is not something that should be prevented. And indeed, the judge below was correct to do so. The second point is control, and this is Lady Justice Yip asked me to take us to L.E. Jones. This case appears at tab 8 of the bundle, beginning on 257. Again, my learned friend has opened the facts of this case to to my lordships. This is the trees case, as it has been described. The Highway Authority was not the entity which was responsible for trimming the trees. So that which could be said to be in de facto or in occupation or near occupation of the highway was not responsible for the trimming of the trees. It was the Portsmouth Council which was contractually bound to do so. They had no occupation or interest in the land upon which the trees sat. It was purely a power granted to them and an arrangement that was created by contract in this case. In considering this to be sufficient to allow them to be liable in nuisance, Lord Dyson, as he then was at paragraph 11, and this appears at 261, sets out the reasoning quite clearly. In my view, the basis for the liability of an occupier for a nuisance on land is not his occupation as such. Rather, it is that by virtue of his occupation, an occupier usually has it in his power to take the measures that are necessary to prevent or eliminate the nuisance. He has sufficient control over the hazard which constitutes the nuisance for it to be reasonable to make him liable for the foreseeable consequences of his failure to exercise that control so as to remove the hazard. Similarly, control lies at the heart of liability of a non-occupying owner for liability when the nuisance is attributable to a breach by him of the covenants of a lease or a failure to exercise his right to enter to carry out repairs. And examples are thereafter given. Drawing that together then at paragraph 12, the court said, it is not necessary to decide whether Portsmouth was an occupier of the highway in this case. What matters is that it had the right and duty to reduce their height so as to prevent damage being caused to nearby properties. Again, the point there is the emphasis of control and the right and duty to exercise powers that could prevent a hazard to, in this case, adjoining landowners. I beg your pardon, in the Ellie Jones case, adjoining landowners. In the respondent submission, we would say that that holds good for the powers and the exercise that is held over the market traders and the duties that that then creates to avoid foreseeable damage to those who are users of the adjacent highway. The foreseeability of the potential damage in this regard is evidenced by the appellant's own standard operating procedures and conditions, which clearly envisage the hazards, health and safety at condition 18, etc., which may arise if items are left out with the pitch limits, or which may arise if aspects such as happened in this case tend to happen. This is clearly foreseeable that if you bring market traders to an area and license and control their market trading activity, there is a risk that one or more of them may abandon their equipment or leave their equipment in the vicinity of the market or close by, thereby causing a hazard on the highway which could trip and injure a claimant, such as the claimant in this case. In that light, when the appellant has sufficient control to abate such nuisances, both through their market officers' supervision of the market and their market officers' powers to remove any items, that is enough in my submission to create the nuisance duty that was held to, or create the cause of action nuisance that was held to be appropriate in this case.
On its own?
Yes, because it is the creation of the market in the first place and the supervisory control, management and regulation of the market in circumstances where it's clearly envisaged by the defendant in their own materials.
Oh, that's different.
I beg your pardon.
All right. Well, sorry. Where it's envisaged that.
Where it's envisaged in their own materials that if market traders were left to their own devices, as it were, there would be a risk that materials would be abandoned around the market or left out sitting out with the market pitches, creating a hazard to those who either are walking through the market or walking adjacent to the market on the public highway. This is clearly a feature that is emphasised by the learned judge below in respect of his identification of the breach of duty, or sorry, the duty of care and negligence. The foreseeability issue, if I can turn up that reference.
I don't think it's not very controversial, is it? Common sense suggests if there is a market like this and it's nobody inspects it, it is foreseeable that stuff will be left lying around. It is
Yes.
foreseeable that some of it might be a tripping hazard.
Yes.
Speaking for myself, that's the easy part.
Well, quite, and it's that leads to the creation of the standard operating procedures and the conditions, which include those aspects, which simply evidence the fact that the defendant appellant had averted to these risks and had sought to put measures in place to do so, but then the evidence that arose at the trial below was that those standard operating procedures were not being adhered to, and that is the basis upon which the judge fixed breach of duty. How that feeds into the nuisance aspect is that it also, those standard operating procedures and conditions demonstrate that the defendant appellant had the requisite power, in addition to that knowledge of the potential for those hazards to be created, to abate those aspects. And relying on L.E. Jones, I say that is sufficient to create liability in nuisance. The reliance on Lipiat has somewhat fallen away, as the judge below had identified that either the hazard was created adjacent to the market or was created within the market area. Lipiat was originally relied on, and I beg your pardon, Lipiat is at the authorities bundle at tab 5. And is it page 150 on, sorry, 149 onto 150? The principle in essence is that there is no rule of law that says that a defendant, that the nuisance must take place on the defendant's land. The activities that constitute the nuisance must take place on the defendant's land in order to constitute a nuisance. This is the travellers who congregated on the council's land. The actual activities that constituted a nuisance were when they left the council's land in this case and then started making a nuisance of themselves, as it were, on the adjoining fields and the adjoining neighbourhood farm. The first aspect that it was relied on below was in order to essentially make that point about it not necessarily needing to be activities that take place on the land, but that they emanate from the land. And in this case, the analogy being drawn in light of L.E. Jones is it's activities that take place within the control of, or the management of, the defendant are sufficient to constitute a nuisance.
I think I've been very slow about this, but at the moment I can't see what nuisance adds to anything. So if for a start, it's a nuisance caused by an obstruction on the highway.
Yes.
It's not a nuisance caused by an escape of smells, people, anything like that. It's Hornbook law that to obstruct the highway constitutes a particular form of nuisance.
Yes.
If the local authority are not liable in negligence, either because they didn't have time to spot the thing, or because their time for breaching their duty had not run out, or because as a local authority acting pursuant to a power they owed no duty, then you're not going to succeed in nuisance where you fail in negligence. And conversely, if you succeed in negligence, you're at least halfway there succeeding in nuisance. But at the moment, we're spending a lot of time and effort discussing whether cases about escapes of land from one person's land to another constitutes a nuisance, and whether it's adopted and means of so on and so forth. But I'm just not entirely sure what the benefit to humankind is in going down this analysis.
Understood. If I can explain it this way, in terms of the first 2 points that my lordship makes, in terms of if we don't get across the line on respect of when this should have been detected under negligence, I say it is still possible to get across the line under nuisance, and for that I again go back to L.E. Jones. So to turn that case up again, tab 8 of the bundle, and in particular I'm here looking at page 264 of the bundle, and it's paragraph 23.
Just giving the page again, Mr. Coffey.
Page 264. And paragraph 23, getting Mr. Bebb accepted. And the short point here is the burden that the claimant failed to give a reasonable opportunity to abate the nuisance rests on Portsmouth. In essence, the defendant, if it's saying that it did not have the ability or the time in which to abate the nuisance, it's upon them to show, first of all, it did not have sufficient time to abate the nuisance, or if sufficient time had been allowed, it would have ensured that the nuisance was abated. In this instance, I say that would get us across the line in respect of the timings on the causation point, if the court is not with us on the timings in respect of the negligence point. And that is why time is spent dealing with it.
Coffey says, effect of paragraph 23 is that even if causation cannot be established in nuisance, in negligence, Tower Hamlets cannot prove the opposite.
Well, in essence,
In nuisance.
in essence, paragraph 23 shifts that burden is my submission.
Okay.
On that basis, the last thing to cover in respect of the nuisance point is to distinguish Alley and Bradford, and why we say Alley and Bradford does not preclude a finding of nuisance in this case. The simple submission, Alley and Bradford is a highways case. This is not a highways case. Again, you've been taken by my learned friend to the judgment of Lord Justice Toulson. I don't ask you to read it again, but it may be worth simply turning it up to have to hand for these submissions. It is behind tab 13. It begins on page 381. And the relevant paragraphs in respect of the nuisance begin at page 390. So
Sorry, I don't understand that submission that this is not a highway case.
the
Why
present
not?
case is not a highways case
Why?
because the appellant are not the highways authority responsible.
It's not a highway authority
I
case.
beg your
It's an accident on the highway.
Yes.
Yes, it is an accident on the highway, my lady. However, the respondent, the appellant, is not a highways authority.
Right, thank
So,
you.
in seeking to rely on Ali and Bradford, they would need to bring themselves within the complex statutory scheme of the Highways Act, which doesn't apply to the present case.
The Highways Act creates powers and duties.
It does create powers and duties, but the key point in Lord Toulson's judgment is that it also creates enforcement aspects. And this is at paragraph 39 on page 391. It begins that the Highways Act provides a complex statutory code.
Yes, I see what you mean. He says it's accepted. Parliament did not intend the breach of a highway authority's duty for the removal of obstructions should give rise to a private action for damages.
And it's because of the line above that. Furthermore, the current legislation contains specific provisions which regulate the powers and duties of the highway authorities with respect to removal of highway obstructions and establish a method for enforcement of the duty. See sections 149 and 150. And that is the classic principle that if a statute creates an enforcement mechanism, you do not then, that replaces or usurps the common law ability to change it, because it would be inconsistent with the statutory scheme to impose the blunt instrument of a common law remedy, as is described here, using nuisance. Those enforcement mechanisms are not present in the 1990 London Local Authorities Act. You've been taken to the relevant parts of that act by my learned friend. There are powers and duties created in that act, but there is nothing in that act that would render it inconsistent with the statutory scheme to allow for a claimant to recover in negligence for the negligent exercise of those powers or duties, or indeed to recover in nuisance if the exercise of those powers and duties has created a nuisance. So Ali and Bradford, the core point of the ratio within that case is that Parliament have created this very complex statutory process. Parliament have said, if you need to enforce it, this is the way you go about doing it as part of the statutory process. Therefore, it would be wrong of the courts to superimpose common law liability, as has been suggested. That's the core point of what Toulson is saying in this case. To the extent that he makes comments at paragraph 36 and yes, to the extent that he makes comments about the requirement in nuisance of the defendant to occupy the land upon which the danger arose and the claimant to occupy neighbouring land. First of all, the requirement to occupy for the defendant to occupy the land, that would be obiter and therefore would not have the same binding authority as the Lord Justice Dyson's dicta in L.E. Jones. And to the extent that it says that the claimant ought to occupy the land damaged by the nuisance, that's clearly private nuisance. This has been pleaded as a case in public nuisance.
Say it again.
To the extent that Lord Toulson says that for nuisance to engage, the claimant must occupy neighbouring land damaged by the activities.
The first point is that it's obiter and it's trumped by
It's trumped by L.E. Jones.
Dyson.
Yes, but the second point is that the requirement that's set out for the claimant to occupy the neighbouring land that is damaged, that's private nuisance. Whereas it's well established that if a claimant suffers special damage as a result of public nuisance on the highway or elsewhere, that is still recoverable in public nuisance. So on that basis, it's respectfully submitted that Ali and Bradford does not preclude a finding of nuisance in the present case, and that the judge below was entitled to, and indeed correct, to make the finding that he did in respect of nuisance. I'm conscious of the time, my
Yes,
lords.
well,
but now do you convene
if
in
you're
moment?
about to leave nuisance and go on,
Unless there's anything further with which I can assist in respect of nuisance.
not at the moment, no. You might think of Borough overnight.
I'm grateful.
What will the next topic be?
I will then be moving on to the remaining aspects of ground one. So that will be first of all the positive action point, if I may put it that way.
Yes,
Then the control point.
yes.
And I won't be dealing in any great detail with the assumption of responsibility point. As my learned friend points out, this is not an assumption of responsibility case.
Yes.
Okay. To the extent that anyone even had any temptations to suggest that it might be, the judgment helpfully handed down this morning has certainly dissuaded that.
Yes. All right. We'll resume at 10:30 tomorrow.
I'm grateful.
Court rise and table.